Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas, this honorable court.
Please be seated. We'll hear argument in three cases this morning. First is 2117, Van Boven against Freshour from Travis County and the Third Court of Appeals District. Then 2354, Centerpoint Energy Resources against Ramirez from Webb County and the Fourth Court of Appeals District. Justice Huddle is not participating in the decision of that case. And then finally in 2523, Matson against McLean from Travis County and the Third Court of Appeals District. The court has allotted 20 minutes per side in each of the three cases, and we'll take a brief recess between the arguments, concluding them before lunch. The arguments are being webcast live over the court's website today and will be available in the archives later. We'll hear argument in 2117.
May it please the court. Dr. Van Boven will present argument on his own behalf. He has reserved 7 minutes for rebuttal.
May it please the court. This dispute is a matter of state law, interpreting the powers granted to the board to prosecute and discipline if a physician commits an offense. And SOA, the legislature has granted the force of adjudicative authority to issue the final ruling. Respondents assert that the board's final order dismissing all charges determined to be unsubstantiated by the ALJ's final ruling is merely a revision of the board's temporary disciplinary order. What the respondents report is not what the board ordered. They claim contesting charges at SOA is not appealing charges. That meeting their burden of proof is superfluous. That, quote, regardless of any evidentiary standard, unquote, federal law somehow empowers them to order a revised adverse action. They assert that their burden of proof is lifted by federal law. This proposed decisional rule is absurd. Prevailing at SOA would mean to be registered and defamed as an offender because it is a list of offenders, of felons, of people convicted for doing unsafe acts for life. That is where I've been listed for 4 years since the dismissal. As Chief ALJ Parsley observes, quote, in short order, the public will come to understand that SOA is not fair. It's not neutral and independent, and that the system is weighted in favor of state agencies, unquote.
Excuse
yes,
me.
Ma'am.
Isn't the answer here to have a very clear rule as to what's to happen when someone like yourself is exonerated? And so that the appropriate way to handle this, just like when we're dealing with statutes, we may not agree with the statute, but it is what it is to go and make sure that the rule is very clear about what should happen in a situation.
And I absolutely agree. It should be the rule of law, not the rule of respondents. And I do believe the law is clear. HB 680, passed in 2011, clearly removed the ability of the board. It eliminated their ability to rule on the merits of their own charges. The legislature divided and separated the powers so that if the ALJ, on an adjudicated case, said that yes, you committed a sanctionable act, then it would return to the board, and then they would be able to determine an appropriate sanction according to guidelines. The contingency, you can't have a punishment without a crime. However, that has been denied. It's replete throughout the record that the board has denied it. They point to defunct rules passed in 2006, asserting we still retain that right. Many agencies do. But that's been gone for a decade, but they refuse to read it. It says point blank that the finding of facts and conclusion of law of the ALJ shall not be changed or modified. They have two choices: to either appeal within 30 days of the final decision, which had already expired, November, that would have been November 18th, or to accept it. The verbiage of adopting a proposal, those are residuals from pre-2011 when they could modify, when they could contemplate. Indeed, when testifying before the House in 2019, they still held fast and under oath as expert witnesses to the House Committee, Public Health Committee. They end up, their executive director maintained that the ultimate decision of guilty or not guilty remains with us. It's patently incorrect.
Well,
Now-
they accepted the ALJ, they ultimately accepted the ALJ's findings and conclusions and chose not to appeal.
Oh, indeed.
Right.
Yes.
So-
However, the board did the right thing. If you read in the context of the statute.
By the time it comes to us now, that's really not the issue. The issue is, how are they obligated to report that to the National
Right.
Practitioners Data Bank?
So,
Isn't that the issue we've got to decide here? Is
well,
how
but-
did the law require them to report it?
I'm indicating that what was reported was not what was ordered. What was ordered was, as you said, dismissed based on the ALJ's finding of fact conclusion law, and they also indicated that this matter is concluded, and based on that finding, that final decision, we have a duty to dismiss. But then they put in a passive phrase that could be manipulated, and it was ex post facto, that said your restriction is no longer existing. The problem is that was manipulated and falsely represented to be a type of a disciplinary order called an order of reinstatement. Never happened. If it was a reinstatement based on revising the original findings, adverse findings, and modifying that original adverse action, and through either me, and you can see in your exhibit there's several examples under disciplinary order where a person, they ended up doing a mea culpa. They got conditions. They were able to correct what they did, or the time lapse of their suspension expired. So with or without conditions, then through their benevolence, they can say, we're going to give you an order of reinstatement. That's reportable because the underlying offense has not been overturned. But the respondents, ex post facto, turned a good order of dismissal into a bad order, saying he committed offense based on our probable cause.
Well, is that the board that did that?
No, the board did exactly what they should do. It's the respondents, ex post facto, it's equivalent to a Trojan horse. They sent a horse to the farm, but it's not a horse, it's a Trojan horse. They end up saying, here's a final order that is in fact a reinstatement order. They did not follow the law. The law is a prescriptive. The steps you have to take if you want to order a reinstatement and rules, none have occurred. And if you look at what's on publicly available, I am not in that category of disciplinary order and individuals who committed offenses, but their punishments have been revised or modified or replaced, superseded. The board did the right thing. That needs to be followed by saying that final order superseded, meaning voided the initial one, and reported as such. Doing that eliminates this problem. And the second thing they need to say is to say, we did not order a reinstatement. That was by the effect of the ALJ's final decision. And I quoted that during the time of the vote. That was made clear. It wasn't lifted by an order. It was lifted by the legal power of the ALJ's decision that undid and overturned, because that's where they had to prove their case. The ISC and the temporary suspension hearings, those are provisional probable cause. And then those are only probable cause. That's not proving their case until trial. The trial in this case is SOA. And nurses, if you have a probable cause hearing in 70 days, and then you have to have trial in 60. Dentists, same thing. 30 days for a probable cause hearing and 60 days for final trial. I was waiting for my day in court for 2 years under a so-called temporary restriction order. It's an oxymoron. And they're calling a dismissal, saying that, yes, he was dismissed, but we make the final ruling, and the judge did not rule on whether Dr. Van Boven was a danger, because we withheld that charge. If you look at their charges, they withheld the charge that I pose a real danger to society. So leaving the question, well, then why did you withhold it? Did you forget it? No. Well, did you not put it in because you decided on your own I'm no longer dangerous to society? No. I would contend they withheld that charge from the SOA judge and then say he didn't rule on it. Why? Because they never followed the evidentiary threshold of standard to even do it. Only 5% of the time does anyone get the rare, egregious temporary restriction that the sky is falling, there's immediate danger. 10 months. They took them 10 months to decide it, but it was only a few weeks after I made complaints about them. But the law says you must have an expert panel report saying you're incompetent and you failed to provide the standard of care. That's in law. They ignored it. They said, well, there's a litany of violations. None of them, individually or in summation, would constitute an emergency temporary action. None of them. They happen all the time. The difference was that, I wasn't able to call that out because I had to exhaust my administrative remedies. And I did. And I prevailed. And the prevailing has made my life and my family's shame and my ability to feed my family. For 4 years, I've been essentially, unemployed. I trained at Harvard Johns Hopkins for 4 years, 3 years at the NIH. I won a $2.6 million traumatic brain injury grant for the Department of Veterans Affairs when I came here. And Governor Perry came and ran. We had an Apache helicopter fly out. We had horses. The cavalry, it was beautiful right under the Capitol. And I blew the whistle on the DA, and I won. And I testified before Congress because they shunted millions of dollars from our wounded warriors. My problem is, I don't know what's best for me personally, but I know what's best for us as a people. Any other questions?
Any other questions? Thank you, Doctor. We'll hear from the state.
May it please the court. Mr. Davis will present arguments for the respondents.
Thank you, Mr. Chief Justice, and may it please the court. Over the course of this dispute, Dr. Van Boven has criticized the board's officials in many different ways. But like his live petition, his brief to this court raises a single issue: whether the defendants acted ultra vires in sending the databank, National Practitioner Databank, a revision to action report instead of a void report. I'd like to focus on that question, and if time remains at the end, discuss the redressability point from our letter brief. Now, so starting with the ultra vires claim. Dr. Van Boven frames that in terms of state law, but here state law just looks to federal law. The Medical Practice Act and Board Rule 187.5 say you have to report to the data bank in accordance with the federal statutes and rules.
Let me ask you, so whenever the board memorializes whatever happened, as far as if they're accepting the ALJ proposal for decision, is that applied uniformly? What is the process for that?
Sure, well, if I could talk about the process that happened here. That's governed by Texas Occupations Code, section 164.059. That governs temporary restrictions. Subsection B of that provision authorizes a panel of the board to impose a temporary restriction, like was imposed here. And then subsection E of that provision reflects that the matter then goes to an informal settlement procedure. And if it doesn't settle, as it didn't here, then subsection F says not that the license holder appeals, but rather that the board files a complaint that initiates a contested case before SOA. And I think that's maybe one of Dr. Van Boven's real problems here, is that, as he mentioned, unlike for dentists or nurses, and the statutes relevant there are cited on page 5, note 11 of our brief, the legislature has not authorized doctors to seek immediate review of a temporary restriction order. And that's relevant here because what we're talking about under the guidebook, that is the U.S. Department of Health and Human Services guidance on how these things are reported. What matters is, for a void report, whether the initial action was overturned on appeal. That's the box that he has to fit this into to say that a void report was proper. And
That's for a
reflected-
revision to action report. Doesn't it have to be modifying an action previously reported to the NPDB?
Modified or superseded. And I think the best reflection of that is on page E61 of the guidebook. That's at page, it's 3 Reporter's Record 185. And the paragraph at the top of that page explains that when an initial adverse action is taken against a physician, essentially an interlocutory order like a temporary restriction, that has to be reported through an initial report. And then in accordance with 45 U.S.C. 60.6b, the revision, including a reversal, has to be reported. And E61 of the guidebook explains how. It says it has to be on a revision to action report. That is, if the initial action is either modified or superseded. And there's no dispute here that the language of the temporary restriction was this temporary restriction will be in place until it's superseded by a final order of the board. And
So this is a standard process, right?
that's right.
And I guess that means that a void report would never issue in these circumstances.
That's right, unless it was overturned on appeal by a court. And we have pages of the guidebook reflecting that that's proper. And if I could focus on that for a minute, that's page E8 of the guidebook, 3 Reporter's Record 182.
I didn't understand the answer. So if the doctor lost and appealed and won in court, then a void report would issue?
That's correct, under the guidebook, yes.
What's the difference between that outcome and the board losing in SOA?
Well, if the board loses at SOA, it has to accept the findings of fact and conclusions of law, but has sole discretion to determine the proper action or sanction. And then if it wants to accept the SOA findings and appeal, it can do that. But that's just not the circumstance we have here. And I think another one of Dr. Van Boven's complaints could be that federal law, including the guidebook, doesn't have a broad enough definition of when a void report is proper. But that, of course, doesn't go to the ultra vires question before this court, because the defendants just have to follow what the federal guidebook says here.
Well, and also follow what state law says, right? So what about section 154.006 that says the board shall remove any record of the formal complaint? Doesn't that mean that they would have to file, wouldn't that include filing a void report?
Well, I believe that provision is talking about a separate set of records maintained by the board itself. And here we're, of course, talking about the national data bank records.
Any record.
Well, the board has control over its own records. It doesn't have control over what is maintained in the data bank.
But it has control over what records it submits to the data bank.
It does, but it has to follow what the guidebook says. It doesn't have authority. And this is one point in which...
Well, does it have to follow what the guidebook says over what state law says, or which way?
Well, state law just says follow the guidebook. And...
Well, it says shall remove any record of the formal complaint.
Well, I guess what I'm saying about that provision is talking about the board's own records, And Board Rule 187.5 says you have to look to the federal rules and statutes as to what to report to the data bank. And that's consistent with the Medical Practice Act 164.060 B4 as well.
Does the state law provide any procedure for appealing a temporary suspension under 164.059?
No, and I think that's the problem. This, again, is distinguishable from the situation that the legislature has set up for dentists and nurses, where there is a right to SOA review of that temporary restriction order. Here, there's not. It just goes through the subsection E process, 059E settlement. If that doesn't work, then
And so that's why there would never be a circumstance, as you read the federal guidelines, there would never be a circumstance in which a temporary suspension order under 164.059 could be overruled on appeal under state law. And therefore, there'd never be a void order.
That's right. If a temporary restriction order merged into a final order that continued the restriction, that could be appealed. But as the statutes exist now, there's no right to appeal that temporary restriction.
Well, no, if the ALJ found evidentiary basis for the sanction and the sanction ended up including a suspension or revocation of the license, that would be an independent order, because the temporary order, the proceeding that leads to the temporary order is ancillary. It's not the same. It'd be a completely different order, just like you're arguing it is now.
Yes.
Just one order would impose a suspension or revocation, whereas this order didn't, because it didn't find an evidentiary basis. But either way, it didn't affect the temporary suspension. The temporary suspension by statute simply ended when the final decision was made.
Yes, Your Honor, right. So I think you're referring to Board Rule 187.61 A and B, right? That's A says it's ancillary, B says the temporary order is in place until it's superseded by. Right, and that's a point that Dr. Van Boven has relied upon, but it supports our point about the unavailability of appeal.
Now, did the board have a statutory duty to initiate the proceeding within 30 days after the entry of the temporary suspension?
I'm not aware of that. Subsection F, I don't believe, has a time limit, and the reason for that is because under subsection E, this is again of 059, that the dispute resolution, the informal settlement procedure can take some time. And
There's a provision in the APA, let me find it, 2001-054C1, that says a state agency that's been granted the power to summarily suspend a license unless expressly provided otherwise by statute shall initiate the proceedings for revocation or other action not later than the 30th day after the date the summary suspension order is signed. And none of you addressed that, but I wonder if, I intend to look, but maybe you'll want to, it's 054C1 of the APA, whether why that didn't impose a duty to initiate the permanent sanction proceeding within 30 days.
Right, well, I mean, I think the more specific statute here would control. I'm not perfectly familiar with that provision, but it hasn't been argued, and so at this point, any untimeliness has been waived. But if I could explain a little bit more why that the disciplinary hearing couldn't be an appeal. An appeal is limited to the record before the initial decision maker. And here,
do you agree that that the obligation to report the actions sort of entails an obligation to report them accurately, and so that if you are misinterpreting the guidelines and the differences between an appeal and a suspension or a superseding, if you're wrong about that, do you lose?
yes, and that's one point where we disagree with the Court of Appeals. We, of course, support the Court of Appeals' judgment. We're asking for affirmance of the judgment. We don't agree with its analysis in full, because it likened this case to McRaven, where in McRaven that was an unusual circumstance where state law gave a state official license to get federal law wrong. That's not what we have here. We have state law saying follow federal law, and federal law saying you got 4 choices, you have to pick the right one. And in that respect, it's a bit like a multiple choice exam where the instructions say choose the best answer. If the court were to look at the guidebook and think, well, gosh, there's not 100% clear best answer, well, there's one that's better than the other. You can eliminate initial report, corrected report right off the bat. You're down to void report, revision to action report. E61 is the clearest indication that a revision to action report was correct. E8 discusses the 3 scenarios in which a void report is proper. And
Focusing there, your brief cites 2 parts of the record for the proposition that overturned on appeal is limited to appeals that in which a decision has been overturned by a court. And so you cite to page E8, and you agree with me that the substance you're looking at there, or that you say supports your position there, is an example. You agree with that?
No, so actually, I don't agree with that. The guidebook speaks in terms of examples throughout, but on page E8, the part I'm relying on, says there are just three things you can have for a void report. One is it was submitted in error. These are bullet points, 3/4 of the way up the page. It was not reportable because it's not reportable under the guidelines.
We're really talking about the third one here.
Yeah, exactly.
Overturned
Or it
on
was
appeal.
overturned on appeal. That's the entire universe of when a void report is proper. The appeal prong is the only one that could apply. That's why I'm focused on, was this an appeal or not?
Yeah, but you're going a step further and saying that that's a limiting factor, that it does not appear here, that appeal can only happen in a court rather at an agency.
So, yes, and that's where.
So I'm trying to understand the support for that. What I see on
Okay.
E8 is that it's an example in which the overturning happened in a court.
No.
The other section you cite on 275 of the record, I don't see any support for the proposition at all. Could you explain how
Sure.
275 of the record supports your position?
So I don't have 275 in front of me, and in fact, that comes from the 2018 version, and here the proper focus is on the 2015 version, the version that was in place when the alleged ultra-virus acts took place. But I think that's irrelevant, though, because I think the language is the same. What I would say is the examples in the guidebook about overturned on appeal all have to do with courts. Now, whether there could be some example that doesn't include a report, it still wouldn't change the outcome here. And in fact, Dr. Van Boven has relied upon an email that he obtained from essentially the help desk or the customer service desk of the data bank that says, this is at page 833 of the record, an appeal can include to a court, and it has some loose language that could suggest maybe an internal appeal could be proper in some abstract scenario. That could be referring to, for instance, a hospital's peer review process. But the reason we know that that doesn't apply here is because it was rejected, considered and rejected by the department in the dispute resolution process. So at page 691, note 2, and 693, note 7, this is the dispute resolution decision on reconsideration by the department. That part of the decision letter acknowledges Van Boven's reliance on that email and rejects it and says, well, no, under the guidelines and under state law that you've provided and your amici have provided and the board has provided, a revision to action report was the appropriate report to file.
So if we think about the purposes of this database and the reporting and its protection of the public from problematic physicians, what is the difference between a overturning on appeal and what happened here in terms of its relevance to the purposes of what this database is about?
So what happened here was that the ALJ found that the board didn't meet its burden to show a violation of the act. That doesn't mean, though, that the initial report of the temporary restriction was improper. I don't think there's any dispute at this
Right,
stage.
but wouldn't the failure to meet your burden be a basis for overturning an initial ruling on appeal?
Well, I think, Dr. Van Boven could argue that, and he could say, the guidebook is wrong. That void category really needs to be expanded to fit this situation as a matter of justice. But that's not a complaint.
Well, I mean, the question, though, is we have these federal guidelines that are, these national guidelines are sort of, they speak in certain terminology, and then we have state procedural practices that don't necessarily map perfectly onto the terminology and the guidelines. So we have to figure out, which proceeding is analogous to which term in the guidelines, and I'm just trying to figure out what the functional difference is, the practical difference between overturning on appeal and what happened here.
Well, typically, when we're talking about overturning on appeal, it would be through the judicial review process.
No, I'm not talking procedurally. I mean, what's the difference in terms of the danger to the public or the purpose of this database?
Well, in judicial review, a court would be saying that the board overstepped its boundaries. And here, where we have only an ALJ saying that the board failed to meet its burden. And I guess Dr. Van Boven could argue, well, that's a distinction without a difference, but it is what the guidebook requires, and it is how the legislature has set up this framework. It hasn't allowed for the kind of appeal that I think Dr. Van Boven wishes he had from that temporary restriction. Because if he had that right to appeal and could fit within the guidebook's appeal language through vindication of that challenge, then...
So is the answer to the question, it doesn't serve the purpose?
I'm sorry, Mr. Chief Justice, it
The
doesn't
question,
serve what purpose?
Justice Blacklock's question was, how does what happened here serve the purposes for which the structure is imposed?
I think from Dr. Van Boven's perspective, it may not serve the purpose based on his view of how the proceedings played out. From the board's view, it does serve the purpose because it accurately reflects the procedural history of what happened here.
But the bottom line is, if a physician loses at SOA and wins in the district court, he's in a better position than if he wins at SOA.
That's Dr. Van Boven's position, and it's something that the legislature could remedy. It's something that could be fixed by changing the guidebook. And it's also something that, to some extent, relies upon how the medical community looks at these reports.
So does that mean he should be able to appeal to the district court because there's still a consequence that's hanging over him from winning at SOA?
So there's a dispute in the briefing about whether he could have appealed that final decision. He didn't appeal that final decision.
But could he have?
And regardless of how the court decides that question, it doesn't say anything about whether he did appeal the temporary restriction, and that's all that matters for this report.
Well, he couldn't,
I'm sorry?
but he couldn't.
He could not appeal that temporary restriction, and that's why it can't fit within the void guide.
But if in effect what happened as a result of this report was that he was sanctioned in essence because he had a scarlet letter on him, then, what's the effect of that?
I see my time has expired, man.
You may,
Again, I think that goes to how the medical community looks at these reports. Dr. Van Boven alleges that the mere fact of the report is what matters to the medical community, whereas as the 11th Circuit in the Leal case noted, that's not necessarily how it has to function. A hospital could decide to disregard the report or do further investigation. But I don't want to use more of my time.
any other questions? Thank you, counsel. Doctor, you have 7 minutes.
The catalog, the guidebook, is a straw man argument. That's a catalog for people who have been found to have committed a violation. It's a national registry of offenders found guilty, and it's a warning It was created by Congress to protect the public from doctors who have committed dangerous or unprofessional acts from slithering through the night from one place to another, so it would signal, beware. That's what it is. It's equivalent to being a felon for life or a sex offender, period. So don't even open the book. You don't need to. This is a state jurisdiction. The question is simply this. In our administrative process, we created SOA so that every case in occupations isn't going to court, to take care of it and resolve it internally because you have the specialized knowledge. So that's why we have SOA, to serve that independent, impartial, adjudicative function. But that has been ripped apart, and indeed, retired Chief Parsley said, look, following this episode, ALJs will also fear actions adverse to their employment if they don't find in favor of agencies. And I would submit to you, because a severed head always commands attention. They have created a tangle weave of no less than 5 theories that are mutually exclusive. The first theory was they hoodwinked the National Practitioner Database and said, the state law, it's state's jurisdiction, it gives us authority to modify regardless of what the judge says, because let's only cite a segment of the law with regards to the provision, and they literally, it was lies by omission, selective out-of-text citing. For each case, the board has sole authority and discretion to determine the action or sanction, and the judge can't make any recommendations. They left out the first part, that they can't change a finding of fact or a conclusion of law of the judge. So National Practitioner Database said, well, based on what they're saying, they have authority and discretion to do what they want regardless of the judge. And they wrote, we can't second guess what their decision making, their language. They stole the term supersede, which refers to if you have a finally adverse action, okay? That's the only thing that's supposed to report. He left out the first part of the sentence, that they're supposed to report public disciplinary board action according to the rules. But if you didn't commit an action, you're not supposed to report it. So they end up saying, well, we've reported this, and they told the National Practitioner Database, we did it with state authority. But the National Practitioner Database said to me, well, you're barking up the wrong tree. We don't have authority to decide the language you're using. Well, they stole your word and made it a new meaning, supersede. It means void, vacates, and they use it in a different context. They're using the word ambiguity, order. Namely, well, it's an order and there's no discipline, but all orders must be reportable, which means they're bad. It's dizzying doublespeak. But the National Practitioner Database said, look, we can't interpret the language in their orders. That's state law. We can't interpret the sanctioning authority. That's state law. We can't determine their intention. We only have to go by what they tell us. Many of your disputes and concerns fall outside our scope of review. This is from the director. He wrote, if you feel the board overreached authority, take it up with the state, because we're saying the state gave us the authority. The person he's talking about, the answer desk, that wasn't a person from the answering desk. That was a senior policy analyst, Ms. Keegan, who spent hours with me on the phone before she followed up with the email address saying, no, this is perfectly legitimate. That's what SOA was created for, so you don't have to go to court. And that was version 2. Version 1 was telling the National Practitioner Database that it's state jurisdiction, and state gives us authority. Version 2, they end up going to the district court and saying, Dr. Van Boven should have appealed the final decision. I was like, what do you mean? I was found not guilty. What is there to appeal? Well, you should have appealed the final order, but you say it's not disciplinary, and it's not until you turned it into one. So what would I be appealing? They said, well, you should have appealed it so you can go back to the temporary disciplinary order. I said, wait a minute, that's been superseded by the final one. And so that's version 2. Again, blaming the state. Version 3 is they hoodwinked the appellate court. They said, listen, and they invoke, this University of Texas case, and they say, gosh, this is a collateral law, and if the president, wants to withhold the HIPAA, in terms of information, he has discretion not to not release it. So that's not committing ultra vires to state law. Well, that's fine and interesting, but it's irrelevant to this case because the law says you can't change the decision of the judge. That rules. There's nowhere in any law and rule or in the guidebook gives just an example of an overrule, but absolutely by definition, by legal statute. When you spoke in terms of, citing the law that said they have to vacate or remove from the record, it's not just the record, it's the whole public record. Because as Representative Frank said when this discussion came up in 2019, he said, don't you have a moral obligation if the judge said he's not guilty to clean his record and remove it from the public record? He said, do we really have to tell you to do that? And Mr. Freshour said, well, no, we can remove it right away. Yes, sir. And then he didn't. So that's version 3, is telling the appellate court that the federal authority says we have to do it. Well, that's not true. You only have to report a disciplinary action. And he talked out of their other side of their mouth saying, well, we didn't give you any disciplinary action. Well, that's why you're not supposed to report it. And don't call it a reinstatement order, because that handout I gave you, look, under disciplinary actions, you've got someone here, they reinstated their license, but we got some other restrictions, and this resolves the complaint. Ralph Brooks, same thing. You're lifting your suspension, but you got to do this, that, and the other. These are conditions. Calvin Lee, okay, we found you guilty, but we're going to reinstate it so long as you do these things. These are examples. The underlying point is that the findings of violations have never been overturned. That's why it's a revised disciplinary order that is supposed to report it. It's in the public record. What's mine? Form a complaint, dismiss. It's not in that family. It's never been made publicly available. So therefore, for them to say, well, but this is a reinstatement order. Well, as I cited to you, there was no reinstatement order. They didn't follow the laws or rules, and they can't do it. And this code thing that I sent you also underscores that when they revise that adverse action, they assume that original offense stayed. They say, don't even bother to repeat the original action and what you did wrong. We already know, because this is just modifying or replacing one bad action with another. We're superseding the bad action. The key word is adverse. There was nothing adverse. Thank you.
Your time has expired. Any other questions? Thank you. The case is submitted, and the court will take a brief recess.
Rise.